All right, good evening. Hi, good evening, Senior.
Yesterday, we started looking at some issues of evidence. We particularly dealt with the issue of relevance and admissibility. We were successful in our attempt to understand what is relevant evidence, where we were able to state that the very equation of relevant evidence is equal to materiality plus probative value. We also define materiality as looking at the logical connection between the evidence that is being adduced and the offense or the crime that's being committed, or the accused person and the crime. Whereas we looked at probative value as the tendency of that piece of evidence to be able to prove or disprove a fact and issue. We also made it clear that our understanding of relevance is a very test for determining what admissibility is. And in so doing, we looked at the very understanding of admissibility in our jurisprudence, where if evidence is said to be relevant, unless, of course, prescribed by law, then it should be admissible. However, irrelevant evidence is not admissible in law. We went on to look at Section 52, which basically specify certain exceptions to the rule of admissibility being relevant, which is to say that even though evidence may be relevant, under certain circumstances stated or considerations which are stated in the Section 52, the law will not admit them. If it's cumulative, if as it is, it's going to waste time, it's going to cause undue delay, and is going to cause prejudice, is going to surprise the other party. The court then can exercise a discretion to exclude such evidence. We also went on to look at character. We looked at what we mean by character evidence. We were able to distinguish, we were able to raise the very general understanding that character evidence generally is not admissible. However, under certain circumstances provided by law, particularly sections 53, looking at sections 54, sections 83, up to sections 86, we are going to find certain provisions on character evidence and which circumstances that character evidence is admissible. Today, we are going to go on to look at some other aspects of the same topic of admissibility. And those are the peripheral aspects, looking at, first of all, illegally obtained evidence, which is to say that if evidence is obtained illegally, or if evidence is obtained in an immoral or illegal way, will the court admit such evidence? And we are going to look at, first of all, two schools of thought, the common law perspective, and also come down to Ghana to come and see how such evidence is treated by our courts. And then we will look at fresh evidence on appeal, how the court also treats that. And then we will move away from the whole discussion on admissibility and end today's discussion by looking at a very prime area of evidence, which is very examinable because the frequency of it being examined over the years is one that is alarming, which is the looking at matters that do not require proof, particularly judicial notice, which is not so difficult to understand. However, they seem to like to examine us on it a lot. Then we can bring today's session to an end. So if you do not have any questions from the discussions that we've had since yesterday, I would proceed to today's discussion. But I would assume that you have questions and give a few seconds to see if anybody can unmute and share your confusion with us. And let's see if we can remedy that confusion that you have. If there is no question, we can proceed.
Okay, Council.
Yes.
Okay, from yesterday, we were talking about character evidence that cannot be introduced except under certain conditions.
Yes.
Let's say the prosecution's witness, when the prosecution is leading their witness in the witness box during their examination in chief, probably they begin to lay a foundation for the character of their witness with the view to prove it to the court that their witness is truthful and whatever the witness is saying is the truth. I, as a defense attorney, can I object to that particular character they're establishing for their witness?
It depends. You realize that when we looked at some of the sections of section 53, before we even looked at that section, we established generally that character evidence is not admissible. So under any circumstance that you would want to, or a party would want to bring up the character, or the accused wants to bring up their character and trying to, establish their innocence, it would have to be within the confines of the law, particularly section 53. If you look at section 53, and I stated on a very lighter note that it talks about instances where if the accused person decides to bring up their character, then it also gives the party on the other side, which is the prosecution, the capacity to also attack their character or discredit their character. So from the question that you asked, it depends, because if they raise up their character, which is basically they are bringing up their good character in a way of showing to the court that they are people of good reputation, and for that reason, the court should also consider that reputation and in their consideration, especially when there's a jury, to also play on the minds of the jury that the person basically is of a good repute, so they should not hold against them. The prosecution, in the same breath, on cross-examination, can also come and rather question that character that you are so much putting forth. So once it doesn't really have to do with the extreme, which is prohibited by 52, which is that once you're not bringing up, the prosecution is not bringing up past convictions and the likes, but is looking at your reputation. A reputation basically is what individuals or others can attest to regarding your truthfulness, your integrity, and other things. Then yes, 53 states the circumstances under which one can use them. However, the moment you bring up your character, then you're opening the floodgates for the other party to also attack it. We are going to, I think someone else has also typed in the chats that we didn't exhaust our discussion on character evidence, so I'll do a recap of it. And in my recap, I'll also look at some of the case law to help, further deepen understanding of character evidence, particularly the case of Avegavi versus the Republic, I believe. And then we will look at the facts and we look at the holding of the court to help you understand better the issue of character. So I hope I've exhausted your question, but if I have not, let me just do a recap on the character before we move on, because it looks as if it's a common concern. Yes, okay. I'm listening to you.
I understand it, but my question is, can I, as a defense attorney, object to the character they are trying to establish for the witness?
Okay. Okay.
Okay, Fatah is the prosecutor. Now he has called his witness, Kofi Abuchi. And leading Kofi Abuchi is the examination in chief. He tries to let the court know that he is a pastor, he's a married man with 5 children. Kofi Abuchi has won many laurels. He has sat on the Truth and Reconciliation Committee of the country. He has always resolved disputes between parties. Example, but my client is the accused, and I, as a defense attorney sitting, whilst watching Fatah, the prosecutor, lay this foundation for his witness. Can I object to that as a defense attorney?
There's no need to object to that as a defense attorney, because I believe that whatever he's doing are within the exception in 53. Yes. So once you are opening up your good character, when it gets to your turn as a defense attorney, what they've done is that they've also given you the weapon or the opportunity to then attack their character. Do you understand? So what it does is that you won't have to object. You just have to allow them to go and note it down that, oh, they've given you the opportunity to talk about character. So as a defense attorney, the most prudent thing you do is that it's a tactical game. As a defense attorney, if they don't bring up their character, you don't get to attack their character, because 53 doesn't allow you as a defense to bring up people's character when they have not brought it up to defend themselves. I mean, as an accused person, to defend themselves. So as a defense attorney, when someone brings up their character, the accused person brings up their character. Sorry, as a prosecution, what you do is that you just allow them to go. Then you come with facts that discredits what you said to show that, well, he's saying he's honest. From this and this conduct, it doesn't show honesty. And also, talking about character, we have instances where he has shown this honesty, even to the court. So in your cross-examination, you can ask him questions like, oh, in your accounts, you said you were here on this day, right? Yes. And what did you see on this day? I was like, I saw this. No, on that day, it did not rain. It was on this other day that it rained. So are you sticking to your words that it rained on this day? The person will go like, oh, sorry, I think it was not on this. Then you realize that your honesty is not so honest after all. So then you get the opportunity to also use your character against them. So this 53 is not given to you so that when someone brings up character, you object. But it shows the confines within which the whole idea of character evidence is admissible within a criminal or even a civil trial. So to answer your question, when someone brings up your character, you need not object on the general rule that character evidence is inadmissible. There are certain exceptions in 53 that you can use as a prosecution to your advantage. And I think it will be more prudent for you to do that rather than object.
Okay, thank you.
All right. So should we proceed, or we should still look at the provisions? I think there are quite a number of questions on the character evidence. So I'll just do a recap. So yesterday we spoke about the facts. We tried to define what character evidence is. And you realize that even from our criminal, not the criminal code, the Procedure Act, Act 30, particularly section 129, you realize that the code states that a person charged or called as a witness in pursuit of this code shall not be asked, if asked, shall not be required to answer any questions tending to show that he has committed or has been convicted of an offense. And we stated that when it comes to character evidence, the prosecution cannot, as it is, bring the conviction, and you can see that in 52, of the accused person up, because then you'll be attacking the bad character of the person, and you'll be swaying the minds of the triers of fact from the conduct that is being tried to other matters which are past and have been determined. If you also look at some of the provisions that we looked at, particularly section 54. 54 deals with the method of proving character. And it speaks about the fact that you should admit evidence in the form of an opinion or evidence of reputation. Now, one may ask, what is the distinction between reputation? Because if you look at 54, 54 says that provides that in all circumstances in which evidence of character or trait of character of a person is admissible, such evidence may only be in the form of an opinion or evidence of reputation, and not in the form of specific instances of a person's conduct. So if you look at section 54, it seems to confine character evidence to general evidence of reputation. Now, you realize that it brings a challenge between what is character and reputation. Hello? Can you hear me? Please, can you hear me?
Yeah.
Okay. So it brings, and we need, in trying to, distinguish between character and reputation, you can look at the case, a very old case of Scott versus Sampson. And in Scott versus Sampson, the courts tried to do that distinction, where they stated that the reason is no doubt that the words character and reputation may have various reasons. Now, a man's character is sometimes said to be, in fact, what he is, whereas his reputation is what other people think he is. So when we talk about someone's character, it's really what he is. But then what we are calling people to come and give opinions on, or when we are calling people to come and try and talk about his character, what we are actually asking them to is come and give their general opinion on who they think he is. But there's always a distinction between what character is and reputation. So more often than not, is used, simultaneously, and it doesn't really have any effect. But what you should know is that more often than not, in a trial, when one opens this case, there are obviously witnesses that are called. These witnesses can come and give opinion on who they think the accused person is and how they think he's a person of good repute. Once any such witnesses are called and they are given testimony as to the reputation of that particular accused person, the prosecution is also then given the opportunity to come and speak about that same reputation, which in turn goes to determine the character of that particular individual. If you look at particularly the case of Avegavi versus the Republic, which is a very instructive case when it comes to character evidence, and I encourage that you read. If I'm to try and hazard an attempt at what the case is about, it really had to do with the fact that an appellant or the appellants in the case appealed against a decision of a high court, which convicted them of charges of robbery. Now, their main ground of appeal was that there was no justification for the court to have permitted the cross-examinations for the first and third appellants as to their previous convictions, and for the proven convictions to have been revealed to the jury. So, in their opinion, because their convictions were brought up during cross-examinations, and then the jury heard, these questions that were asked, or these issues that were brought up regarding previous convictions, the jury were, in their opinion on appeal, the argument was that the jury was prejudiced. So during the trial, the third appellant stated that, I do not know, in his submission, the third appellant stated that he did not know if the sergeant concocted the statement which he says he made, and he never begged that same sergeant or anyone else that he had done any wrong. So because of that, the sergeant then assumed that, oh, he had attacked him or he has called him a liar in court. Therefore, he, on cross-examination, decided that since he has brought up he, the sergeant, the prosecutor's character in the matter, he, the sergeant, was also going to lead evidence regarding his character and went on to bring on his previous convictions in the matter. So on appeal, the court had to make a determination on this particular issue of character evidence. And then the first authority that the court cited on appeal was the authority that I stated in this particular discussion, particularly section 1295 of Act 30. And in 1295, it stated an accused person cannot be cross-examined as if his previous conviction and bad character, or it cannot be cross-examined on those things because it basically prejudices the minds of the jury of fact in that particular matter. It is his conduct in this matter that is in trial and not his previous convictions. So it will be in bad faith for the court to allow his previous convictions, not when judgment is being given, but when the trial is being, or when the case is being heard, for these previous convictions to be brought up. So you realize that the court, in making that decision, basically spoke about the fact that, and we've already seen this yesterday when you looked at section 52, where we spoke about the fact that even though some evidence may be relevant, for reason that it might prejudice the court, or it might prejudice the mind of the judge or the jury, the court has a discretion to not admit such evidence. So I would only advise that, because you don't want to waste so much time on character evidence, I advise that you read the judgment of Eninje, in the case of Avegavi versus the Republic. Avegavi is Avegavi, and it's very instructive when it comes to character evidence. All right, I don't want to waste so much time on character evidence because even though it might sound very confusing and interesting, it's really simple. Character evidence generally is not admissible. However, under section 53 of the NRCD, you realize that they've stated some circumstances where character evidence may be admitted, and is admitted when an accused person brings it up, the prosecution can raise up their evidence. When the accused person brings up the character of the victim, same or likewise can be done regarding his character and other circumstances which are stated and we discussed into a little more detail yesterday. So I would want us to move on to our discussions for today because we have quite some things to do today. So the first thing we are going to discuss today, and if you have any questions, you can leave it in the chat box. After, I'll try and deal with them. Now, evidence obtained by illegal or unfair means. And before we went back to reiterate, I was talking about the fact that, first of all, what do we understand by evidence that is obtained by illegal means? When evidence is said to have been obtained illegally or improperly, what is referred to is evidence which has been acquired or procured, right, by methods which fly in the face of the law or which defy certain standards of the law or standards of morality, or are generally contrary to the sense of decency and propriety. So if how the evidence was obtained, and anytime we are having a discussion on this, you can easily think of our own journalist vigilante and us, and how the methods, which in quote, unconventional methods that he uses to acquire his evidence. And this is basically what some may call illegally or unfair means of obtaining evidence. Now, what I need to know is that when it comes to this issue, there might be at least two schools of thought on the inclusion or otherwise of illegally obtained evidence. Now, the first school is that no one should be allowed to benefit from an unlawful or improper conduct. Okay, I'm sorry. So then if you look at it, you realize that basically the law does not allow for someone to benefit from illegal or improper conduct of acquisition of such evidence, right? So basically, if you look at this particular school of thought, you find someone like Broby, and I'm sure most of you use this book. He holds this ideology that no one should be allowed to benefit from an unlawful or improper conduct. Now, in Broby, he states that the first school is to the effect that the finding or outcome of illegal or improper search should not be admissible because the tainted source or the tainted procedure should be considered as tainting the finding of the search.
I understand it. I think that we must enter into Rafa. I cannot represent that.
Sorry, I have to mute everybody. So it's basically taints the finding of the search. Now, this is similar to the American principle that you cannot be allowed to, so basically that evidence becomes a fruit of a poison tree because basically it was acquired or it was grown unlawfully or was grown through unorthodox means. So another argument advanced in support of the same view is that a criminal justice system should protect the individual from abuse of state power or intrusion. So if you look at the 1992 Constitution, there are certain provisions in there that seek to protect an individual from such intrusion, just in the name of trying to, as it is, fight crime, or the state trying to, protect, its interest. You cannot intrude into people's lives. So if you look at particularly Articles 14, 2 through and other statutes, it provides a safeguard for the protection of suspects by the laws on crime and investigation. So the proponents further also argue that that illegally obtained evidence, right, if we allow it, it will encourage police and crime investigators to continue to trample on the liberties of citizens. If you look at particularly article. Hello, Peter. Okay. If we particularly look at article. If you particularly look at Article 14.3, it states that a person who has been arrested, restricted, or detained should be sent to court within 48 hours. Now, this provision implies that if evidence is obtained from a person who is detained for more than 48 hours, the excess period of detention will make the detention illegal. So you realize that this is supposed to, then again, prevent abuse of the liberties of individual. I think with these constitutional provisions, the one that I feel is most relevant to the protection of, is basically the protection of privacy of the individual, Article 18.2, which states that no person shall be subjected to interference with the privacy of his home, property, concurrence, or communication, except in accordance with the law or for the prevention of crime. So you realize that it will be unconstitutional for an investigator to bag someone's or put a microphone, hide something in someone's house or in someone's car, or plant these listening or video devices elsewhere to listen to people's conversation. And also to understand this, the scope of this section, you might also be interested in reading the case of Edmond Addo versus the Republic. Now, if you look at Ghana, it's important to realize that in Ghana, the admissibility of illegally obtained or improperly obtained evidence may sometimes depend on the nature of the procedure adopted in the investigation of the case. So if you look at the nature, particularly of the case, it will depend. So if you look at the nature of the case, it will determine how the court will treat it. And usually, because there are no particular provisions in the Evidence Act, which basically talks about illegally obtained evidence, because when they spoke about the exceptions regarding the rule of relevance, they did not state anywhere that if the evidence was gotten illegally, it cannot be it cannot be admitted. It is at the discretion of the court to look at some superior provisions. If I say superior, I mean constitutional provisions, which guarantee the liberty to, or the right of privacy, to be able to protect the ordinary individual. Earlier, I mentioned the case of Edmond Addo. If you look at the facts of the case of Edmond Addo, you realize that an individual who had some sort of sexual relation with a young lady who happened to be a minor, because the young lady was not above the age of majority to be able to consent into such sexual engagement. And this young man, because he wanted to have a leverage over this young woman, videoed this young woman and used the video to blackmail her from time to time. At a point in time, from the fact that was narrated, the young lady got tired of the blackmail and decided that I won't do it again. So this young man then, or it was realized that this young man had released this video into the public domain, for which reason he was arrested. But then the real issue regarding illegally obtained evidence came when the police invaded the privacy of his phone to be able to acquire to be able to access certain evidence of his phone, on his phone, and use that same evidence against him. And the courts had the opportunity to also make certain pronouncements on the very idea of the evidence that was obtained in the scope, because they had raised an argument that the evidence that was obtained in an improper manner, or improper fashion. So I believe that if you look particularly at the facts of this case, it's going to basically give you that understanding. Now, moving on, you'd realize that at common law, the position on admissibility or otherwise of illegally obtained evidence was stated in the case of R versus Lintham, right? And in R versus Lintham, the quotation or that principle was that it does not matter, right? It does not matter how you get it. If you steal it, or even whatever you do, it would be inadmissible in evidence. So it does not matter how you get it. If you steal it, even, it will be inadmissible in evidence. So if you look at this particular common law position on the admissibility of evidence, you realize that in some cases, the solution to the problem posed by this approach has been narrowed down to the nature of the offense. So in looking at the offense, the court gets to make a determination that yes, this person committed, and usually if it's an offense which is of higher gravity, like for example, murder, or there's going to be a loss of life or limb, the court, even though such evidence was acquired in an unorthodox way, the court might be prepared to, yes. So the court might be prepared to basically, pay some attention to that evidence that is given. And if you look at certain cases also, you realize that these discussions are had. In Ghana, one can say that the test for admissibility of evidence, as we've all seen, is relevance. If you look at section 5.2 and 5.3, you realize that all relevant evidence, as we discussed yesterday, is admissible, except as otherwise provided. Now, no evidence is admissible also, except it is relevant. So the question will, however, be that whether the discretion of the judges in excluding relevant evidence and admissible evidence, as provided for in section 52, which talks about the exceptions, extends to evidence obtained by illegal means. Because as we've already seen, that was not one of the exceptions. Because generally, the evidence, once is relevant, and for example, if someone was going to commit murder, or was attempting to commit murder, and there was a camera hidden somewhere, and it captures the person, because of the gravity of the crime, if that evidence is relevant because it's material to the murder, it also has probative value because it can prove that indeed this particular person was the one who attempted the murder. However, when we look at some of the considerations, which are basically moral and legal considerations, we are saying that really that evidence that was acquired, it was by a hidden means, or you recorded me in a phone conversation when I had no knowledge of the fact that you're recording me. So that evidence was acquired in an illegal way. Section 52 doesn't say that relevant evidence of that nature can be excluded for the reason that it was acquired by an illegal way, right? But however, you realize that that evidence, some may argue that that evidence may have prejudicial value. That is, if the evidence is of probative value, it may matter not how it was obtained, but some may just argue that it has prejudicial value. But there is no express provision in 52 that bars the court from admitting such evidence. So one can say that in Ghana, as in the common law jurisdiction, it does not matter how you get the evidence, right? Even if you steal it, it may be admissible because there's no express provision that states that once the camera was hidden, it should not be admitted. So in Ghana, it's fair to say that we still generally go by this common law position in the case of R versus Lentham, which states that it matters not how it is acquired. Once it is relevant to the case, on a case-by-case basis, the judges can exercise a discretion to admit evidence if they feel is relevant, and even if it was acquired by some means which one may think is unconventional or unorthodox. So I believe that that's the position of the courts. However, there has been some cases where, based on the peculiar circumstance of the case, the court might have made certain determinations, which basically points to the fact that they are not going to admit that evidence or not. Going to admit that evidence. So it's still, an area of the law where there's more often than not some disputes or some, different, uncertainty or different opinions regarding judicial, decisions. But you should know the general principle or the policy rationale behind the fact that such evidence is admissible under some circumstances and under others is not. the common law principle is that it matters not whether it was acquired by hiding a camera. Once it is relevant, is admissible. And then people have sought to reason that because there's no express provision in the exceptions in 52, that states that if it's acquired by illegal means or immoral means, it should be excluded. Once evidence is relevant, the rule says that it should be admissible. Others on the other school are stating that, well, there's right to privacy. And the provision states that relevant evidence is admissible unless provided by law. Therefore, once there are some provisions that guarantee privacy, and you putting a camera in someone's room is a breach to their rights of privacy, then that should be a reason why evidence acquired by some illegal means should not be admitted. Well, you can form your own opinion. And also, your opinion can be grounded in law. If you look at the case of Kubaji, Raphael Kubaji versus the Republic, you'd also realize that the court also, makes certain pronouncements regarding the same area, where in that case, the understanding that the court gives is also, relevant to our discussion of whether or not it should be admissible. If you look at the case of Kubaji, you realize that the court does a broad discussion. So look at the case of Edmond Addo. The case of Latham, R versus Latham, it basically states a common law principle. You need not really go into the facts. But looking at the case of Edmond Addo and looking at the case of Kubaji versus the Republic, it gives you basically a sense of what the court basically looks at when determining issues of evidence acquired by those means. Yeah. So those are the ones. I believe someone else also asked for the facts of Kubaji. So with Kubaji, it also had to do with the same issue of illegally obtained evidence, where during the court, what's it called? During the process or the procedure of a court trial, there seemed to be some evidence of someone's recording a call, right, from one of the parties. And the court had to determine whether that recorded call or that evidence that was being brought, which was a call which was recorded without the consent or concurrence of the other party, was evidence that could or should be admitted by the court. The court also made a determination on that, and in doing so, the court stated that it's on a case-by-case basis where they need to look at the cost and effects of they admitting such trial, that if it will be for the greater good, or if it would benefit or help them to resolve the matter, then it is one that they will take the risk of admitting such evidence. But if the effect of admitting it is not going to be in the best interest of both parties, or also coming to justice or doing justice, then the court will not want to toe that line, because then if the court does that, it only gives the other party one more ground to appeal. So I'll just advise that you look at these two cases, Edmond and Kubaji, to deepen your understanding of this principle of illegally obtained evidence. There's also the idea of fresh evidence on appeal. Before we move on, does anybody have questions on this particular issue of illegally obtained evidence? Okay. Nobody has a question yet. And in looking at, the illegally obtained evidence, you can also look at the case of R versus Apicella. R versus Apicella is also an interesting case. You can look at it. It had to do with 3 people who were, an accused person who was convicted of 3 counts of rape. And then all the victims of the rape seem to have contracted a strain of gonorrhea. So when he was put in cells, he was basically lied to that he needed a sample for something unrelated. They took a sample and also tested it and realized that he also had that same strain of gonorrhea that was found in the 3 victims. So they attempted to use that particular evidence in court that, you rape people, you are denying it. However, it looks as if the gonorrhea that they contracted from you raping them, you have the same gonorrhea. And the court had to make a determination whether or not they were basically the admission of such evidence was proper or not. The Court of Appeal flatly rejected the submission that the evidence was physically equivalent to an oral confession. And it was held that the use of evidence was not unfair and that the judge was correct in exercising his discretion not to exclude the evidence. So the court upheld the common law principle, the principle that it matters not. He raped the girls and he's denying it. So if there is a way possible, whether he was told his samples were being taken for one reason or the other, once the samples are relevant, which is that it shows that he committed the offense of rape, which in the opinion of the court, looking at the cost analysis, you realize that it's a very serious offense. So if that was the only way for the court to expeditiously, deliver justice, then the court was going to take it. And they weren't going to go into immorality and illegality. There was still evidence. So yes, that will be all for illegally obtained evidence. We'll move on to fresh evidence on appeal. Now, when it comes to fresh evidence on appeal, you'd realize that there's a rule in law, and it is a principle that parties must adduce all relevant evidence in a case during trial. Accordingly, it is not generally permissible after a case has been disposed of for a party to subsequently bring fresh evidence when he's appealing. So the law, however, recognizes that in some circumstances, the rigidity of this rule or maxim must be relaxed. And a party who proposes to offer fresh evidence on appeal is required to satisfy certain conditions. And these conditions can be seen in the case of AG versus Marshall, particularly the dictum of Lord Denning. Now, Lord Denning stated some particular conditions that must be met. And that's really what fresh evidence on appeal is. That first of all, the general principle is that parties must adduce all evidence during trial. And generally, fresh evidence is not allowed on appeal. However, under some circumstances, and those circumstances are stated in the case of AG versus Marshall, Lord Denning, you realize that the court allows for that. And these rules are stated as one, that the evidence could not have been obtained with reasonable diligence for the use in the trial. So if that evidence, that's fresh evidence, right, could not have been obtained at the time of the trial, even if they had exercised reasonable diligence, they wouldn't have obtained that evidence to bring before the court. Then on appeal, if the evidence is brought, they will consider it. Secondly, the evidence must be such that if it was given at the trial, it will probably have an important influence on the result of the case, although it need not be conclusive. So if the new evidence that they are bringing is so important that if it was brought during the trial, it would have influenced the decision or would have swayed the decision. It need not make the decision conclusive, but if it has the effect of swaying the decision of the court, then on appeal, the court will consider such. And lastly, Lord Denning stated that the evidence must be such that it is presumably to be believed, or if in other words, it must be credible, though it need not be controversial. So then that evidence that they are bringing must be of high credibility. So these three things should be there: that the evidence could not have been obtained by reasonable diligence. Also, that evidence should have the important influence of overturning the results, and also that evidence should be credible or should be believable by the court. If you look at the case of if you look at the case of Kakari versus Yafi, in the case of Kakari versus Yafi, the court also looked at this evidence, this very rule of fresh evidence on appeal. And then the judge stated that the general rule was that each party in an action before the court must produce all the relevant and material evidence in support of its cause. Now, the court will not be permitted, or the court will not permit a party to produce its evidence piecemeal in an action. That litigation must definitely come to an end. Therefore, in a trial, what you are expected to do is to bring all the evidence that speaks to your case. Now, the court will not be permitted or will not permit a party to bring its evidence in piecemeal. However, there can be certain exceptional circumstances where the court would have to look at such evidence. And the court might, in such cases, grant leave for you to adduce fresh evidence in a hearing of appeal. So the court will have to basically grant you the permission to adduce such evidence on appeal. It also to look at the same issue. And also in the case of Akari versus Viafi, it had to do with application in which in his affidavit, right? So the applicant in his affidavit in support of his motion, where he was seeking leave to adduce fresh evidence on appeal, made certain averments that during the original trial or original suit at the High Court, one Kobina gave evidence for the plaintiff respondent and revealed that he had one time been sued in connection with the particular case we're handling, which had to do with Abuaji Farm, one of the farms in which the present dispute at the court was about. Now you realize that they were not able to, as it is, bring all the evidence regarding that matter to bear. So on appeal, they sought leave to bring some evidence which they felt to be relevant in the determination of the matter. And then the court basically had to go through the process of looking at the principles that were laid in the case of AG versus Marshall to see if in that case, that if they had taken all diligent steps, or if they are taking all the reasonably diligent steps, they would not have come by that evidence. And then, for them to be able to allow or admit such fresh evidence on appeal. Also, the court also looked at whether or not it really had the potential of overturning the decision. That's evidence that they were bringing. Was it important, or could it influence the decision of the court? And lastly, if that evidence that they were going to bring was even credible enough. And there are other cases that you can also look at, particularly the case of the Republic versus Adama Thompson, ex-party, Eninakwa, the second. So in that case, to the applicant and 10 others who were the respondents in a contempt application before the High Court, where they had engaged in non-compliance with orders of a judicial committee, they said that the orders required that they should hand over the Basis to regalia or some paraphernalia of the stool when they had left the stool and a new what's it called, Basis manche had been installed. Now, the respondents were convicted of the offense of contempt. Now, on appeal at the Supreme Court, which was dismissed, they appealed to the appeal of the Court of Appeal, which was the appeal to the Supreme Court, and they sought leave to adduce such some fresh evidence. And the evidence that they wanted to adduce really had to do with newspaper publications and pictures and letters stating that the persons were of good reputation, and then they were also kingmakers of the particular stool. And then the Supreme Court refused the application because it was on the basis that it did not satisfy the criteria. The criteria being that these publications that they were trying to bring in to basically prove that they were full of good reputation and also that they were kingmakers in that particular area, it was available to them at the time of the trial. If they had exercised reasonable diligence, they could have come by this evidence and would have made this argument during the trial. So on appeal, the general rule is that you are not allowed to adduce fresh evidence, and they did not meet the exceptional circumstances or the yardstick that the law sets to allow fresh evidence on appeal. So I believe that there are other cases that basically deals with fresh evidence on appeal, but for the purpose of this class, I believe these cases does justice to understand of fresh evidence on appeal. It's really simplistic. General rule is not allowed. Under certain circumstances, if you meet the threshold or the considerations that was raised by Lord Denning in AG versus Marshall, then the courts will allow you or grant you leave to adduce fresh evidence on appeal. Please, any question before we move on to a very important discussion on judicial notice? Please, can we proceed?
Yes, senior, we can.
Are we all okay? Do we have any questions regarding what we have done? And for information, what we just did is all part of the rules of admissibility. So it's fair to say that we've completed all the topics and subtopics of admissibility and relevance. As you can see, it's not anything out of this world. The illegally obtained, as I told you, is a discussion matter. You need to read wide to be able to make a very sound argument, whichever position that you take regarding the cases that you read. When it comes to fresh evidence on appeal, it's possible that they can set questions on it, but it's not a very broad area. So if you read it, you can easily answer a question. It's a bonus question if they bring a question on such an area, because it's not too difficult to grasp. And admissibility is also not a difficult area. Subsequently, after we do about 3 topics, we will try and solve a question or 2 regarding the topics that we've done, so that you see the shape and form in which they set questions on some of these areas. All right, judicial notice. Judicial notice is an interesting one, and it's very examinable. Even though it looks as if last year the questions they set, which was problematic, they didn't set so many questions on judicial review. I think during the previous years, we've had a lot of questions on judicial review. Judicial notice. So we will look at that. So if someone has the act, please, I'll be grateful if someone can read section 9. The person can be on standby to read section 9 for me. Now, to start our discussion on judicial notice, we want you to understand that in evidence, facts in issue need to be proved by means of adducing evidence, which is to state that under every circumstance, when one is coming to prove a fact in issue, they need to adduce evidence. They need to be able to use the various tools of adducing evidence or prove the guilt or otherwise of the accused person. Now, under certain circumstances, you realize that in evidence, there are some matters that do not require proof. And if we say these matters do not require proof, all we are saying is that these matters, the law doesn't expect that that burden to prove is exercised, because these matters are notorious. The courts and everybody sitting there can agree that it's what it is. And in the Gen Z language, they go like that, like everybody knows this. So, you don't need to prove it. Move on to more more contested issues. Also, when someone makes a formal admission, the person admits that, yes, I did this. The other party doesn't have to come and prove it, because the person has made an admission, and you don't need to come and prove it. And also presumptions. And I believe you also look at presumptions. Presumptions too are one of the matters that do not require proof. I'm taking my time to explain this because in exam condition, when you get a question on any of these three, you are expected that if you are stating the area of law, you state that matters that do not require proof, particularly judicial notice. Matters that do not require proof, particularly presumptions, because they fall within the broad umbrella of matters that do not require proof. Good. And you understand why they do not require proof, because judicial notices, because of its notoriety, everybody in that jurisdiction can agree that this is what it is. So when it comes to judicial notice, the general rule is that all facts in issue or relevant to the issue in a given case, the general rule is that it must be proved. In other words, he who makes an averment or he who avers must prove, as was held in a lot of cases. You can, especially in the case of Bank of West Africa versus Econ. That's a 1963 case. However, under certain circumstances, that particular burden to prove is taken away. Now, judges are permitted by law to relieve a party who bears the burden of producing evidence from the necessity of proof. That is that the requirement of proof is dispensed with. That means that under these three, things that are mentioned, the judge dispenses with or has a discretion to dispense with your burden to prove them based on any of these things that are stated. Now, it simply means that there's a recognition by the court of the existence of a fact or something without requiring you proving the same. So the rationale is that if a fact is well known or its existence is so easily determinable from unimpeachable sources. Unimpeachable sources means that they are on doubt, like it's not in doubt, right? Those sources are available to everybody. It's a common source. It's a general, so everybody knows it. It will not be good sense to require you to formally prove it. So the judge in such a situation declares that he takes judicial notice of the fact or directs the jury to take judicial notice, although a party offers no proof. Do you understand? So, for example, a judge may take judicial notice of the fact that Sit March 1957 was a day Ghana gained independence. And Sit March, so for example, in a case where Sit March 2004, someone did something, blah, blah, and you're going like, the court can take notice of the fact that, well, we are not counting that day because the holiday, nobody goes to work. It's a notorious fact. You need to go and prove that Sit March, it's a holiday, my lord, I was not at work. It's not a matter that you need to prove with alibi that you were at home, or obviously you could not have been, like, it's a holiday. So it can dispense with you proving that Sit March is a holiday, or Sit March was Independence Day, or some other facts which is notorious in nature. So that's the very essence of it. On this particular call, one of the most notorious facts would be that Fatah Mahama is aspiring for what's it called, SRC president. It's a fact everybody in the school knows because he keeps on throwing his flyers around. The last time I saw him, he was wearing some jalabia and wishing us what's it called, one of the Muslim festivities. And the last time he was wearing a good suit and it was Independence Day. It's a notorious fact that he's aspiring for a certain position. So we can loosely use the term that we can take judicial notice of the fact that he has an intention to become SRC president. And that is clear. So if we use the term judicial notice, Fatah dispenses with the burden of coming to prove or convince us that he has intentions of aspiring for SRC president, because it goes without saying that he's aspiring. Like, everybody knows that it's a notorious fact within the Ghana School of Law community that Fatah Mahama is an aspirant for the SRC position. So that is basically what by unimpeachable. So if you go on WhatsApp, if you go on Twitter, if you go on Instagram, all the social media is being posted there. So it's an unimpeachable fact from every reasonable source that Fatah Mahama is an aspirant. He shouldn't come and prove to you, or he shouldn't come and disprove the fact that he is or he's not. So that's the very idea that the judicial notice holds. If you look at Section 9, right, of NRCD, or Act 323, it governs the taking of judicial notice of facts in issue or facts relevant to the facts in issue at any stage in action. Now, judicial notice can be taken only of facts which are either so generally known within the territorial jurisdiction of the court, or so capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned, right? So that's the fact is not subject to reasonable dispute. So when you are looking at, judicial notice, what you are looking at is notoriety and the fact that the sources are unimpeachable or unimpeachable sources. So it's very important that we pay attention to that. If you look at Section 9.2a or 9.2b, you realize that the reenactment that the second level of judicial review, you realize that I keep on saying review, notice, I'm sure I started this. Judicial notice really has to do with facts which are well within the knowledge of people in a certain jurisdiction, and facts whose accuracy cannot be reasonably be questioned, because the fact that the source is also impeachable. You'd realize that the fact judicially noticed can be noticed without inquiry. And it's very important that we pay attention to some cases Because if you look at section 9, it basically spells out the very rule or principle of judicial review. And since I don't have my act here, if Nella is on the call today, I would ask Nella to read. If not, Nella's best friend can read for me. I'll crave your indulgence. I don't think Nella is on the call today.
A minute, please.
Okay, thank you. Oh, Nella is here.
Yeah, so judicial notice, section 9. 1. This section governs the taking of judicial notice of facts in issue or facts which are relevant to the facts in issue. 2. Judicial notice can be taken only of facts which are A. So generally known within the territorial jurisdiction of the court, or B. So capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned, that the facts are not subject to reasonable dispute. 3. Judicial notice may be taken whether requested or not. 4. Judicial notice shall be taken if requested by a party, and the requesting party, A, gives each adverse party fair notice of the request through the pleadings or otherwise, and B, supplies the necessary sources and information to the court. 5. A party is entitled, on timely request, to an opportunity to present to the court information relevant to the propriety of taking judicial notice and the meaning of the fact to be noticed. 6. Judicial notice may be taken at any stage of the action. 7. In an action tried by jury, the court may, and upon a timely request, shall instruct the jury to accept as conclusive the facts which have been judicially noticed. I'm done, please.
All right, thank you. So you realize that the act basically states the conditions under which a judge may exercise his prerogative to dispense with a party proving a certain fact. And you realize that it's a very long list. However, we'll take our time to go through it one after the other. Now, the conditions that are stated under this list, you realize that the first condition for judicial notice is that the facts should be commonly or generally known in the community. That fact that the judge is taking judicial notice of should be generally or commonly known in the community. That is, the fact should be so well known that everyone in the community can be presumed to have knowledge of it. First condition. The second condition is that the fact should be beyond dispute. That is that the fact should not be one in respect of which different people share different notions or opinion. It should be certain and should be definite. In other words, the fact should be beyond dispute or context or controversy. And then the third condition is that the fact should be such that if anyone cared to cross-check it, it can easily do so from sources or places which cannot be disputed and yet arrive at the same accurate conclusion that the fact exists. So you realize that judicial notice dispenses away with inquiry. Now, a number of cases in which the court has taken judicial notice without inquiry, and the justification is that the fact in question was too notorious to be subject to any serious any serious inquiry. And you realize that in some cases, for example, in the case of Ney versus Niblett, you realize that the court took judicial notice of the fact that cats are kept for domestic purposes, that men and women share a bed, are likely to have sexual intercourse. If you look at the case of Wu versus Wu, if you look at the Niblets case, the court took judicial notice of the fact that you don't need to prove that a cat is a domestic animal and cats are kept for domestic purposes. If you look at the case of Wu versus Wolf, the court took judicial notice of the fact that the men and women sharing a bed are likely to have sexual intercourse. Now, what are you saying? That you are saying that a man and a woman share a bed, and then there's a likelihood that once a man and a woman shares a bed, there's a likelihood that they would have some sexual intercourse. If you also look at the case of Gibson versus Bon Callahan Hotel, you realize that in that particular case too, it was held on appeal that the judge gave a ruling which did not share in common with the average community, which was that I know the Callahan Hotel as well. I know the Callahan Hotel as well as a witness does. And in that case, you realize that the people of the community did not, it was not a proper way of taking or exercising judicial notice, where you say that, oh, I know the hotel as well as the witness does himself. So you realize that with the test for taking judicial notice, it should first of all be very notorious facts, and then it should be from unimpeachable sources. The very, very interesting, case or authority that helps to do justice to our understanding of this idea of judicial review will be the case of R versus Mensah and others, right? And in this case, you'd realize that it has, it's a very popular case that we might all have heard before. But in this particular case, was a former finance minister who was charged with sedition. Now, at the trial of the director, what happened was that the DPP, which is the Director of Public Prosecution, led evidence to prove that J.H. Mensah wrote a document couched in very strong and rude language, criticizing the Champon government of mismanagement and misadministration. Now, the trial judge decided to take judicial notice of the fact that the economic ills of the country were due to world inflation, and held that the document was seditious and consequently convicted and sentenced the accused person. So what I'm saying is that J.H. Mensah, who was finance minister, went to publish some things. And in the publication that he made, he criticized the Champon's government and said that they were corrupt and they had mismanaged the country and a whole lot of things. In the trial against J.H. Mensah, the judge decided to take judicial notice of the fact that the economic ills of the country, just like we are saying that the economic problems now of this country are due to COVID and the Russian-Ukraine war, the judge also decided to take judicial notice of the fact that the economic ills of that time was due to world inflation, and therefore held that the statement that G.H. Mensah had written was basically seditious. So on appeal, the High Court, Cranton Adom, Cecilia Cranton Adom, held that judicial notice refers to facts which a judge could be called upon to receive and act upon either from his general knowledge of them or from inquiries to be made by himself for his own information from sources to which it was proper for him to refer. And she went on to state that to take judicial notice of the fact, however, the judge had to be convinced that the matter was notorious, as not to be subject to dispute among reasonable men, or that the matter was capable of immediate accurate demonstration by readily accessible source of the indisputable accuracy of those facts he was stating. Therefore, the fact which the trial judge took judicial notice of, in that case, could not be classified under this definition. Because to say that, oh, the economic problems of Ghana there is by world inflation is not a notorious fact. It's an opinion. And judges cannot take judicial notice of their opinions. The judicial notice that they take should be facts which are notorious to everybody. Everybody should be able to agree that yes. And the sources to verify those facts should be unimpeachable. That is not as if, oh, some sources are saying this, some are disputing it. It should be a well-accepted fact by general sources that yes, indeed, this economic crisis is caused by this. Again, one cannot make a sweeping statement about world inflation being due to oil crisis and extent to which this country has been affected without basing such observation on any evidence. The judge also went on to state that the court has not a proper forum or is not a proper forum for the evaluation of economic factors which contribute to inflation. To that extent, he felt that it was a wrong exercise of the powers of judicial notice. So if you read the case of R versus Mensah, it's a 1979 case, in particular the judgment of Cecilia Kranti-Adoji, you realize that she discusses the very idea of judicial review, judicial notice. She talks about what judicial notice is supposed to be. She goes on to also look at the statement that was made by the judge, the trial court judge, which in her opinion did not meet the criteria for judicial review of notoriety and also unimpeachable sources. And for that reason, she believed that it could not be said that, it was a proper exercise of judicial review. Also, a judge may nevertheless take judicial notice of facts which are either notorious or notoriously known, nor common knowledge of inquiries. Now, if you look particularly at the section 9.2b that was read by Nella, the section provides that judicial notice can be taken only of facts which are either generally known within the territorial jurisdiction of the court, one. And please pay attention to territorial jurisdiction of the court, such that if a judge sitting in Accra seeks to make judicial notice of some facts which are territorially known in some other jurisdiction but Accra, or even out of the Ghanaian territorial jurisdiction, it cannot qualify to be a proper exercise of judicial notice. Or B, capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Now, the fact that it is not subject to reasonable dispute, that is, the fact that it includes inquiries into historical facts, questions concern the existence of various customs or matters of professional practice, and political questions can be. So the fact is that judicial review can be exercised if, like we know this, that the Ashanti Kingdom fought in many wars with the British. The Golden Stool, from all the historical facts that have been stated, was conjured from the sky by, Okonfo Anochi. And then the Golden Stool represents the spirit of the Ashanti people. Now, this is a fact that is known. It might not be known on a personal level, but from unimpeachable sources, which will not reasonably, or we cannot reasonably question, we can agree that basically this is the state of things, or this is a fact, which is known within the Ashanti Kingdom. So if you look at some cases, for example, in the case of Hiloji versus George, and I'm sure you might have met the case of Hiloji versus George in what's it called, traditional evidence. You would realize that in Hiloji versus George, the court attempted to take judicial notice of certain historical facts and documents. That was where the facts in the book in dispute. So in Hiloji versus George, you realize that there was a book that was written that they tried to basically tender in or rely on its content or its narration or historical narration. And where the facts of the book were in dispute, the courts could not or should not take judicial notice of such facts which are in dispute. So in Hiloji versus George, the Supreme Court ruled that the Court of Appeal erred when it took judicial notice of facts in a textbook which had been challenged, because the very fact that they are challenged or an inquiry was made into the credibility of those shows that it doesn't even qualify, because then the sources is impeachable, and also, I mean, even though it might be notorious, the sources are impeachable. So historical facts and documents, even though we can take a historical fact, so judicial notice can be taken of the following, even though we can take judicial notice of these historical facts under certain circumstances, the court will not be able to do that. We can also take judicial notice of certain political and administrative matters, right? Because it's notorious that this is what it is. And we can also take notice of some administrative matters that it is notorious that this is what it is. We can also take judicial notice of some customs and professional practices. And some of the customs and professional practices is Ghana School of Law and how they go about their things in a certain way. It's a professional practice you can say is improper, but any person who has any judge sitting in court can go like, well, you can agree that Ghana School of Law, if you pass this number of courses, you'll be allowed to go. If you pass this number of courses, you'll be allowed not to go. So if you look at the case that basically was being sent regarding some years ago, the 499 matter, you'd realize that even though there might not have been a standard for examination, it was a notorious fact that there was a certain yardstick that was used over the years. And from everybody that was in the legal space, have gone through law school, lawyers, we can all agree that we know what the yardstick is. So at any point in time where that changes, we can be very sure that even without too much proof, we know, goes without saying that this is what the professional practice has been for a period of time. That if you get 50 plus 1, you are passed. So at any point in time when there's a dispute, a judge cannot take judicial notice of a contrary view, because then it will not be notorious in that particular jurisdiction. Now, if you look at judicial notice of the law, judges are deemed to know the law, and you cannot be ignorant of the law. However, judges cannot be said to know foreign law and take judicial notice of foreign law, but our law, judges can be said to know. And also, which judges cannot or should be wary of taking judicial notice of personal knowledge, of things within their personal knowledge. And if you look at the case of Cubson versus Bon Gallahan Hotel, you'd realize that they basically, and I spoke about it earlier, that basically the caution was thrown, that when the judge said that you know that hotel like I do, that is personal knowledge, something within your personal knowledge. So the judge will ordinarily not be said to have exercised the discretion of judicial notice or the prerogative of judicial notice in the proper manner. Basically, that will bring us to the very scope of judicial notice. Yes, judicial notice. Please, if you have any question, I was moving too fast. You did not understand anything, you can ask so that we deal with it. Please, is it fair to say that we are all okay? We understand, or we've understood all that has been discussed? All right. So if you have any questions that you've not asked or cannot ask here, you can contact Fatah Mahama. He's my brother. He has my contacts, and I can assist you in any way that you can. Subsequently, we'll look at other things. I'm sure because we started with matters that do not require proof, we'll subsequently look at formal admissions and presumptions. And then maybe after looking at that, we'll look at some sample questions regarding these areas and see how we can apply the knowledge that we've taken in our subsequent meeting. So in our subsequent meeting, we'll look at formal admissions and presumptions. Then we'll try and solve a question or two with a little time that we have left. All right. Thank you very much for your attention and for joining me. Have a lovely evening.
Thank you.
Thank you.
Theophilus.
Thank you. Thank you.
Thank you so
Thank
much.
you, and thank you, Fatah.
You're welcome.